Well, hello everybody, good afternoon and welcome to this lunchtime webinar on Professor Iris van Domselaar's article, The Role of Legal Professionals in Large-Scale Miscarriages of Justice, a Virtue Ethics Perspective. I'm Anna Donovan, Director of the Centre for Ethics and Law and an Associate Professor of Corporate Law here at UCL Faculty of Laws. Iris's article is, of course, of pressing and timely importance. Regrettably, we are coming together today at a time when the role of lawyers in numerous miscarriages of justice has come into question, such that the issue of professional ethics is of critical concern. Indeed, in the UK earlier this year, the Legal Services Board issued a consultation on upholding professional ethical duties. Given its importance, the Centre for Ethics and Law is delighted to host today's webinar and for Iris to share her paper and insights with you. I'm also very pleased to say that we're joined by two incredibly distinguished experts in this field, Dr. Karen Nokes and Professor Stephen Mayson. Whilst none of our speakers need an introduction, it is my honour as chair to briefly do so. Professor Iris van Domselaar is a professor in legal philosophy and legal ethics at Amsterdam Law School, where she's the founding director of the Amsterdam Centre on the Legal Professions and Access to Justice. Iris is also the director of the Professional Ethics Programme at Amsterdam Law School. Her research focuses on how to account for ethical quality in legal practice, exploring ethics as a lived experience on the part of legal professionals and of citizens who are affected by their decisions. Dr. Karen Nokes is a lecturer in professional ethics here at the Faculty of Laws at UCL. Karen's work on the Post Office is, of course, well known, and she is, amongst many other things, a co-investigator on the SRC-funded project, Professional Pathologies, Causal Pathways, and the Post Office Miscarriages of Justice. Professor Stephen Mayson is an honorary professor here at UCL and a bencher at Lincoln's Inn, where he's also chair of its regulatory panel. Stephen is, of course, the author of the Independent Review of Legal Services report, in respect of which the second supplementary report was released last year, exploring the meaning of public interest. All of Stephen's reports, I should say, are available on the Centre website. Karen and Stephen are also both co-authors of the CL's response to the recent Legal Services Board consultation that I mentioned earlier, and we're delighted that they could join us today. In terms of proceedings, today's event will follow more of a conversational style discussion, meaning that Iris will introduce her paper for about 20 minutes or so, following which Karen will offer her thoughts on the paper and discuss key aspects of Iris's findings with her. Thereafter, Stephen will similarly share his perspectives and explore pertinent aspects of the paper with Iris. Time permitting, the webinar will conclude with a Q&A section, so please do feel free to submit your questions using the Q&A function. And I know that Iris is very keen to hear your thoughts and to engage with you on her paper. I will moderate that discussion and will attempt to ask the speakers as many questions as time permits. Please note that today's event will be recorded and the recording will be released on our website shortly. So with that, I'm now delighted to hand over to Iris. Iris, thank you very much.
Yes, thank you, Anna, for the generous introduction and for the invitation to present here at the UCL webinar. And thank you also for all the participants for joining us. It's, of course, also a great honor that Karen Nokes and Stephen Mayson, whose work I so much admire, will comment on my paper, which, in view of my field of expertise, legal philosophy and theoretical legal ethics, is quite a bit outside of my comfort zone, to say the least. So by way of background, this paper I started while I was working on another project to develop a citizen-center-oriented virtue ethical approach to legal professionalism. And as part of this project, I wanted just to use a few examples to illustrate my theoretical point. And then in addition to the childcare benefit, to which I'm quite familiar as a Dutch citizen and scholar, I stumbled upon the post office scandal and the Robodebt scandal and other scandals, other large-scale miscarriage of justice. And I simply could not stop reading and watching the victims' statements and the statements of the legal professionals during the public inquiries that were conducted. And it then felt as a choiceless choice to engage more closely with these mass injustices. Also, because I happened to be interested in the topic of the intersection of legal professionalism, moral cost, and virtue ethics. And also because where the methodology of normative legal scholarship is concerned, I fully subscribe to Judith Clark's claim that as normative legal scholars, we perhaps should engage more directly with the phenomenon of injustice as a valuable object of study in and by itself, and injustice as a lived experience. So in the words of Sheklar, I simply want to consider injustice differently, more directly, and in greater depth and detail, and also to eliminate a common condition, victimhood, and especially the sense of injustice it expires. So it's in the spirit of this, her approach to injustice, that the paper is written. So let me then now start also in Sheklarian vein, introducing you to the sense of just injustice of the victims of these mass injustices. No compensation can undo the pain and shame inflicted on me and on so many other parents. My life has been ruined. My family life was all destroyed. My wife has suffered devastating and changing illness, and my daughter almost died. I do remember driving home at night and myself worrying about this money and thinking whether I should just drive my car into a tree and make it stop. These are the cries of injustice of the victim of the Dutch childcare benefit scandal, the UK post office scandal, and the Australian Robodebt scandal, which have occurred in the last 2-3 decades and led to widespread debt, bankruptcy, severe poverty, wrongful imprisonment, mental and physical health problems, family separations, and I should say in the context of the Dutch childcare benefit scandal, large-scale out-of-home placements of children, and for all scandals, also suicides. In these, if you will, legal carnages, legal professionals played a troubling facilitating role. Hence, one of the many questions that have been raised in the wake of these scandals is, where were the legal professionals? Should they not have acted differently and done more to protect their fellow citizens from these injustices? Especially, as goes without saying, their professional role is so closely tied to the ideas of the rule of law, justice, liberty, and equality. And because of the central role of legal professionals, the central troubling role, and given the fact that their failings have occurred also despite a range of principles and rules being in place, I think that the lens of virtue ethics might be valuable, not only as an explanatory framework, but also as a framework that can be used in thinking about how to prevent these professional failings from recurring. So in this paper, I used the lens of virtue ethics, which, not surprisingly, assigns a central place to virtue in the context of legal professionalism in accounting for moral quality and also lack thereof in legal practice. And just to set the stage, what do we mean then by virtue? What is meant by virtue? I think Snow has provided a really beautiful definition. Virtue is a disposition well entrenched in its possessor. Something that, as we say, goes all the way down, unlike a habit, such as being a tea drinker, to notice, expect, value, feel, desire, choose, act, and react in certain characteristics way. So the focus is, in the virtue ethical approach to legal professionalism, on how legal professionals should be, instead of exclusively on what they should do. The structure of the paper is as follows. First, I discuss the 3 large-scale miscarriages of justice by also telling the story of a few of the victims. And then I go into the troubling role of legal professionals in more detail. Then I try to identify the main lessons from virtue ethics. From a pragmatic point of view, if we want similar professional failings from recurring. But as these scandals, and I think this is also really important to note for the legal profession in general, are not mere incidental anomalies within Western justice systems or bugs of the system that simply can be repaired or overcome. No, there are manifestations of what I think, in Hannah Arendt's words, the terribly and terrifyingly normal the way current justice system work. So these scandals also provide lessons for a virtue ethical approach to legal professionalism, at least if it is to meaningfully contribute and realistically contribute to preventing these scandals, or more specifically, these professional failings from recurring. So what I will do in the remaining 15 minutes, I hope, and I really would like to be there, that there's plenty of time for discussion, is to briefly go to these building blocks of my arguments. The scandals themselves. So this is the quotation of Dulce Gonçalves Tavares, one of the more than 40,000 victims of the Dutch childcare benefit scandal, which has been qualified as the largest miscarriage of justice in Dutch history. It involves false accusations made by the Dutch tax administration in its attempt to regulate the distribution of childcare benefit, thereby using discriminatory algorithms to detect fraud. In many of these cases, the tax authority of the tax administration reclaimed full childcare benefits, often between 10,000 or 20,000 euros, in response to minor administrative errors or discrepancies made by the benefit recipients. And parents, particularly those from ethnic minorities backgrounds, were thus wrongfully labeled as fraudsters and were forced to repay the whole amount of the childcare allowance, even if the discrepancy was really small, like 70 euros, as we shall see. So far, the Dutch childcare benefit scandal. Lee Castleton is one of the many victims from the post office scandal, which involved over more than 1,000 sub-postmasters, owners of post office franchises. Now, branch owners of post office franchises who were wrongfully held financially liable and prosecuted for accounting shortfalls caused by bugs in the Horizon system, digital retail and accounting software that they use. Needless to say, this led also to severe consequences for the sub-postmasters and their families. And it was not until 2019 that a High Court ruling in the collective action case Bates versus Post Office exposed the significant flaws in Horizon and criticized the Post Office handling of the cases. So far, the Post Office scandal. In the paper, I also tell the story of Ms. Bevans, one of the victims of Australia's Robodebt scandal, which is about the Australian government using an automated system, the online compliance system, to identify and recover alleged overpayments from welfare recipients. The program's automated debt collection relied on flawed calculations, averaging the annual income based on figures provided by the tax office, instead of using the welfare recipient's actual fortnightly income, as was required by law. More than 500,000 benefit recipients faced unlawful debt collections also with dire consequences. Poverty, mental health problems, stress, suicide, divorce, and so on and so forth. So in the wake of all three scandals, public inquiries have been conducted, and the report of the inquiry in the Post Office is to be expected soon. So I draw largely also from the other reports in this paper. And also, to date, in all three scandals, many victims are still waiting for compensation. And the design of compensation schemes turns out to be highly difficult, and the risk of secondary victimization looms due to perceived and sometimes actual unfairness of these compensation schemes. So one of the serious concerns is that these compensation schemes turn out to be a second trial for the victims. So where were the legal professionals? In the paper, I don't discuss this in real depth, but I do describe the central legal professional groups that have played a causal enabling role in these scandals. In the Post Office scandal, the most prominent group that's mentioned are the in-house and external lawyers, less so the judges. In the childcare benefit scandal, the judges are really in the forefront of critique for so harshly applying the law strictly and formalistically. And also the government lawyers are largely criticized for disrespecting citizens' really basic procedural rights. And in the Robodebt scandals, the government lawyers are mostly criticized for insufficiently fulfilling their independent role as legal advisors. And I think a shared criticism on all the legal professionals involved, and of course, I should say, exception aside, there were a few legal heroes here, but there are few. I think we could summarize also the criticism analogously to this quote from the report of the Parliamentary Committee on the way the institutions worked. I think we could say that the legal professionals overall were blind to people, blind to justice, and blind to people's rights. So we need a change. And then the question I address is, what lesson can be drawn from a virtue ethical approach to start with? So here I identified 3 lessons, and I won't go into them deeply for reasons of time. They can be, I explore that further in the paper. First, the claim from virtue ethics that we should dismiss an outside-in approach to legal professionalism, meaning an approach to legal professionalism that focuses very much on the normative force of rules, principles, or external measures to secure moral quality in practice. And it comes together with a rather impersonal ideal of legal professionalism, seeing the emotional affective side of the professional as something that can primarily hinder also the professional perspective. So for the following reasons, generating unjust outcomes, not solving the problem of discretion, ignoring motives, vision, and attitude, and relying on the idea that knowledge is sufficient for acting rightly. So for all these reasons, I argue that an outside-in approach to legal professionalism should be dismissed. And I illustrate this in the context of these large-scale miscarriages of justice and what the legal professionals did therein. The second lesson, I think if we want to prevent these professional failings from recurring, we should focus very much on development of professional legal virtues. Most importantly, the virtue of practical wisdom, the virtue of justice, virtue of independence, and courage. I won't go into the methodology and how I select then the relevant virtues, but in the paper I used a negative approach by identifying the virtues that I think were mostly missing in these scandals, and that does also have a huge explanatory force for the professional failings. So the lawyers, the governmental lawyers in all these scandals lacked the virtue of justice. Many of them lacked practical wisdom. They lacked independence in all these scandals, which is striking. And often they also lacked courage. And here are some of the examples that I discuss. And then third lesson, I think this is one of the strengths of virtue ethics, that it has really a story to tell in how to cultivate virtue and to develop professional virtues. And the story is as follows, that we should focus very much on formative background practices, on the quality thereof. So that can be family life, primary and secondary education. Of course, the quality of legal education is important, but then it should be understood as a practice, as a site where you can exercise, trying to habituate, trying to just in confrontation with the particular, to practice, exercise, and building, as it were, your professional identity slowly and on a piecemeal basis. And this is, of course, also highly relevant for the important question of how we should develop our legal ethics education. I think from a virtue ethical approach, the pervasive method, here using Deborah Rhodey's term, is one to follow. So not isolating the topic of legal ethics into a separate course as if it were not relevant in other domains of law throughout the curriculum, but really trying to integrate it throughout the whole curriculum. And also to foster a sense of responsibility on the part of our future legal professionals to confront them also already with the cries of injustice and sensitize them with the moral cost of what they can possibly will do later as professional. And one of the questions that has thus also been raised has been, in the wake of these scandals, where were the law schools? Are these scandals not an indication that also the law schools are failing in this regard? Finally, a virtue ethical approach to legal professionalism holds that we should take the impact both of role models, both negative role models and positive role models, seriously. And so it is not a surprise that in these scandals, also largely senior legal professionals have failed in their professionalism, thereby also giving a bad example to their more junior colleagues. And there are plenty of examples thereof. And this is just a slide to show that we are also working in Amsterdam hardly and thinking about, well, how to foster responsible legal professionalism and critical legal professionalism among our law students. But this is a challenge for several reasons that we perhaps can discuss. So finally, I want to, I have 4 minutes, briefly go into the lessons for virtue ethics, which I find really important, that theories of legal professionalism, be it rule-based or principle-based, are realist. So I'm not so fond in this context of ideal theory, so to say. I think we should use the methodology of non-ideal theory and force theoretical approaches to be sufficiently responsive to the actual conditions of justice system, of the way justice systems work. So I have identified 3 lessons in this regard, but I think there are more. One very important lesson, and differently put, this is a blind spot so far for virtue ethical approach to legal professionalism. Virtue ethics in general and virtue ethical approach to legal professionalism does not focus very much on the importance on context and environment in which one is raised and in which one is habituated. And this is already very much stressed by Aristotle. And I think in this really nice quote that you will see here. But it's focused exclusively on these formative background institutions and doesn't say contemporary virtue ethics doesn't say a lot yet on the fact that in modern societies, contemporary societies, as citizens, but as professionals, we live in organizational context. And this is really an under-researched area. So what would then be the relevance for virtue ethics? Well, first, the influence of organizations on the formation of professional character, precisely because it's not about the one-off influence that has been so much studied in empirical experiments. So you happen to be confronted with an authority figure. No, in organizations, you are confronted with an authority figure on a continual basis and in a coordinated way. So more likely that it not only affects your behavior, which the empirical experiments have shown, but it goes deeper, it will affect your professional identity. So this is something that virtue ethics has to take into account. Second, from the organizational dimension, I think virtue ethics has to say more about institutional vice and institutional virtue. And this is very much, and I discussed that, can be illustrated in the Large-Scale Miscarriages of Justice, where institutional vices have been identified, one of which, very prominent one in all of these scandals, so that's another, I think, interesting finding, has been the will for ignorance, or the culture of secrecy, that has played an important role in the post office scandal, and also in the Robodebt scandal, in the childcare affairs scandal, of the injustice or the malfunctioning systems. Just the knowledge thereof remains unknown to the public, unknown to the courts, and thus the injustice could continue to occur. So, and related to that, so if there's also institutional vice or virtue, we can also, virtue ethics would also think how what a virtuous organization would look like and how that then would foster virtuous legal professionalism. But finally, in relation to that, virtue ethics needs to say something about the problem of many hands. The fact that legal professionalism in contemporary society takes place in an organization, and thus that many others are involved in what they do, and that hence it is difficult to identify who is morally responsible for what and on what ground. And I think this sort of under-researched space also allows for all sorts of excuses that are related to this problem of many hands to work or flourish. So virtue ethics, I think, has to have a critical bite in how to assess all the excuses that have in fact been given by the many legal professionals involved in these scandals. And in the paper, I discuss a few examples thereof, like I played only a minor role. It was my client who asked this to do all these. So if I would have done it, the Supreme Court would have decided similarly, etc., and so on. So far, the organizational dimension. An important resemblance in all these scandals is that digital systems have played a crucial role. And so for virtue ethics, it is challenging because so far the conceptualization of virtue relies very much on just a legal system being still print-based, rather than to a large degree also digitalized. So as a relevant avenue for future research for a realistic approach to legal professionalism is also to address the question, which techno-moral virtue are needed, and do legal professionals need to foster responsible data practices within legal and public institutions? Again, I won't go into that deeper. I draw a bit on the work of Shannon Valor in this regard, but I do think that honesty, particularly in relation to digital systems and the role of legal professionals therein, that honesty might be a really crucial virtue also to take seriously. Honesty, of course, about the malfunctioning sometimes of also these systems. Finally, and also to conclude, I hope in a way now that it goes without saying that these scandals that in these scandals, the rights of large groups of socioeconomically disadvantaged or middle-class citizens have been grossly violated, and that there are issues there also of equality. And in fact, these scandals, due to their scale also, and the characteristics of the victims, highlight that in Western legal order, perhaps a two-tier or even three-tier justice system exists. One form of justice for the state, big companies and socioeconomically powerful citizens, and other for little people or ordinary folk, and perhaps even yet another for those outside the ethnic majority. So, of course, this is a problem for any approach to legal professionalism, but as I stress in the paper, in particular also for virtue ethics because of its elitist character in a way. And my proposal is that then virtue ethics should try to address this risk of fostering actual relational inequality within the justice system by focusing so much on the virtue of the legal professional. And so I mentioned three themes that it should take seriously: that of diversity, that of perhaps civic friendship, that we should, in addition to the virtues, we should also foster an attitude of civic friendship on the part of legal professionals. And it should take the topic of restorative justice for the reasons I mentioned in the beginning, that it's a whole challenge already now to restore trust in a way and respect now the current rights of these victims. And then the question could be raised, which sort of virtues are needed on the part of legal professionals to contribute in a meaningful way to such a process of restorative justice. I leave it here. Thank you so much. I think it has been clear that I have been stressing a dark side of our current Western justice system, but I think, as I see that so many are joining us, I hope on a positive note that we can collaborate together in thinking how to prevent these professional failings from recurring. Thank you.
Thank you, Iris. Food for thought indeed. And I know someone who has an interesting perspective to share is Karen. So Karen, perhaps if I could pass over to you now.
Thank you very much, Anna. And firstly, I'm delighted to be able to comment on and engage with Iris on this paper, which takes a virtue ethics perspective to explore the role of legal professionals, as we've heard, in large-scale miscarriages of justice. Scandals like these, as you just finished with, need to be explored in as many ways as possible by the widest set of people, in order that we can collectively shed light on the myriad of failings that took place by individuals, organisations and institutions, so we can do two things. Firstly, we can prevent anything like these scandals occurring again. And secondly, we can learn from them as to what they tell us about everyday action and behaviour, at a point which I'm going to turn to now. And I wanted to make two comments on the paper before I ask you a couple of questions, Iris. The first is about what we can learn about everyday behaviour from these scandals. I was beyond pleased to see the reference at the start of your paper to these scandals arising from how systems and legal professionals typically operate. This is such an important point. And I wanted to labour it for two reasons. I think, firstly, it's all too easy to see these scandals as some extraordinary phenomena, a clear departure from the norm and something that is implicitly rare. And while that view prompts us, academics, policymakers and others, to look deeply into them, this perspective also has a downside, because it can lead people into thinking that those scandals are somehow over there, that it would not happen in a place like this, and it would not happen to people like me. And just looking for the bad apples or the bad barrels as explanations for this type of wrongdoing can blind us to the possibility that one day it might be you or it might be me. And secondly, you're referencing to the scandals as involving the typical, I think, brings the mundane to the fore. I think sometimes scholarship loses sight of the mundane. The processes involved in these scandals were typical and mundane. They were pervasive. They were taken for granted. And it is the taken for grantedness that can lead to people blindly engaging in them without question, saying it's the way that things are done around here. So recognizing these scandals involving the mundane is really important. So my second point is, and I was really pleased again to see that you make the points and in your presentation about the range of legal professionals involved and the types of unethical behaviour or professional wrongdoing. This is also important. The wrongdoing in these scandals cannot be pigeonholed to one type of legal professional doing one type of role. These scandals involve lawyers in private practice, in-house, government and judges too. And the Dutch childcare scandal, as you said, that the judges had a prominent role in, as you say, taking a hardline interpretation of the law. And the spectrum of behaviour concerned, ranging from the incompetent, perhaps the lazy, the leveraging of advantage of position, maybe the lawful but not awful, escalating to the unlawful and potentially criminal. The failures of these professionals engaged in their everyday systems and processes, widespread in this sense, and hence that's why the learning needs to take place from these scandals, and that learning is applicable to all. And the approach that is very tempting to take of, there is nothing to see here, everything's okay with us, is not helpful to anyone. It's not helpful to the legal profession as a whole, but it's also not helpful to the public that legal professionals serve. So I commend you on this paper and I urge everybody to read it. And my first question is about the outside-in approach. You quite rightly warn of the dangers of relying on the outside in preventing similar scandals in the future. So the use of codes or guidance to keep professionals kind of on the right rails, an approach taken by the Department of Social Services in the Robodebt scandal. You make the point on page 17 that outside in approaches focus on well-defined choice situations. And what I was really interested in is, as many problems encountered by legal professionals and also issues of ethics involve situations of uncertainty. And so what advantages do you think a virtue ethics perspective has for legal professionals solving these situations of uncertainty?
Thank you, Karen, for your observations, which I of course endorse, and also for pressing question, because indeed I think uncertainty is, well, one could say on the best interpretation is sort of thoughtlessness. How do you say thoughtlessness used, or on the worst interpretation, or the worst examples, and I think the post office scandal is the point that you make, and Richard Moorhead, is that it is fully exploited. So the rails we need in order to limit, I think, the limit these gray zones, so to say, or from a sort of rather technical language perspective, is thick or shared ethical knowledge, about what fairness is. I mean, fairness also, the meaning of fairness largely depends on our way of life, of our way of doing. And so this is a bit of a Wittgensteinian approach, but I think to assign meaning as lawyers, that we should do in a social context, as a community, as a society. So virtue ethics takes this dimension, to answer your question, very seriously, that in the end, it also boils down to using certain concepts in a way that they are internalized, so that one recognizes on the spot that certain behavior is cruel. And we need this sort of sensitivities in order to limit the scope of discretion, the experience scope of discretion for instance, lawyers when using their litigation tactics. So I think virtue ethics has a lot to say, can limit the domain of uncertainty, although of course there must be room for pluralism. I think that's also important for your ethical approach in a rural society.
And my second question is about facets of virtue, power and power dynamics. And exploring the facets of virtue, you discuss the role of courage and independence. You cite an example from the childcare benefit scandal about where even those who disagreed with the way that appeals were being handled followed instructions from their superiors. A whistleblower is quoted in reference to a junior colleague, say being they're really worried about losing their job. So we seem to have this dynamic interplay of virtue, of authority and self-interest with power. So is there a risk that a virtue ethics perspective does not provide enough prominence to the issue and the influence of power in these everyday institutions?
So yes, I think this you really point to the Achilles heel of a virtue ethical approach, but on the defense, I think to all approaches, normative approaches to legal professionalism, and perhaps to all normative theories of justice and morality, that they have just are not sufficiently responsive to power dynamics in the end, determining, also influencing the way we interpreted rules or deal with rules on a concrete daily basis, and therefore non-ideal theories propose to focus more directly also on relation of domination, inequality. And so one of the findings, well, I don't know if it's yet a finding yet, but on the basis of the empirical studies now on these scandals, is that it seems that legal professionals who are supposed, of course, to temper power, be it from the government or corporate actors, are themselves so much also subject to power relations, so in a way that makes it impossible for them to live up to the promise of their role that is intimately linked to this idea of the rule of law, which is to temper power. I think power is everywhere, so I'm not going into I do address it separately. I mean, it's so in the independence, courage, I think then it has something to say, but on the more sort of systemic level, I think this is also really a weak spot in a virtue ethical approach to legal professionalism. But as I said, as I explained in the paper, I think it should not be seen as an isolated approach. So it can only work if we also, on a more societal level, think along these virtue ethical lines. And then the risk of corporate power and the rule of companies rather than the rule of law, yeah, that is also lurking a bit. Yeah.
Thank you, Iris.
Yeah.
Thank you, Karen, and thank you, Iris. If I could turn over straight away to Stephen now. Thank you, Stephen.
Thank you, Anna, and thank you, Iris, for a fascinating, insightful, thought-provoking, and given the circumstances of the miscarriages, really quite sobering description of the role and influence of lawyers in the way these things have played out. I think, like you, virtue ethics is probably not my natural territory, but it is inherently attractive because I think at one level it could provide the moral compass or the moral fibre that we would like to see lawyers and other professionals demonstrate. And in fact, if you don't like the moral intonation there, then maybe it is about professionalism or the creation of a professional identity. So I do think it's really worthy of further thought and conversation. But I have to say I'm slightly troubled by what appears to be the personal or internalized nature of virtue ethics, because it seems to me that you say in the paper that virtue is not innate. At which point I think I would see virtue then as being socially constructed. As you go about your life, as you go about your interactions, as you go about your learning and development, virtue in one way or another emerges or it doesn't. And so it must have contextual influences. And again, the paper accepts that. Virtue is at least partly developed in the context of the collective. So I'm slightly struggling with this individual versus context, environment, collective, call it what you will. And that sort of leads me to wonder whether we can totally reject the outside-in approach, because that is, after all, the natural stance of lawmakers and regulators. Their principal tools to determine and influence behaviour, particularly of lawyers, are rules and codes of conduct. So I think there's something there about the essence of virtue ethics and its relationship with outside in. I suppose my bigger question that I'm edging towards is whether there's a golden thread missing from a virtue ethics perspective that could bind the elements you describe, wisdom, justice, courage, independence, bind them together, as well as address the three dimensions that you've identified for further research. And apologies to those who know me, but you won't be surprised to hear me suggest that I think the origins of that golden thread lie in the idea of law as a public profession.
Yeah.
That is, as a profession that gets its license to operate from the state on behalf of the public, and then owes obligations to that public and the public interest to behave in a certain way. And I'm just wondering whether that provides more of the collective or environmental context for playing out of virtue ethics. So let me ask more specific questions, if I may. A cursory reading of what you describe as the virtues might be thought to be covered already in the professional codes of conduct. So you look at wisdom, isn't that just competence and acting in the best interests of clients? Justice requires supporting the rule of law and fulfilling one's duties to the court, and courage requires demonstration of independence in standing up to more powerful interests or arbitrary behavior. So in what sense would you say that virtue ethics in those senses really is different to the rules and codes of conduct that are imposed?
Thank you so much. These are really compelling questions as well. And luckily, we're going to have also a dinner tonight. So look forward to discuss them in depth. Just briefly, I think also your work on the public interest and also the role of a legal profession as a public role is crucial here. And perhaps I tried, so it's captured indeed by the virtue of justice, meaning that a legal professional should have internalized the idea of the rule of law as a nomos and the rules, and also bring to bear these sensitivities in concrete cases where, of course, there might be a tension between, for instance, the client interest and the rule of law. So yes, I think that dimension could be stressed a bit more, and I try to capture it with the notion of civic friendship, because what I do think is that what is very prominent in all these scandals is that there is a lack of a sense of solidarity on the part of legal professionals with the citizens that are affected by their decisions. So, or fraternity or a civic ethos. But that has also to do with an attitude and being oriented in a particular way in what one does. And I'm not so just to say that is perhaps the lessons of virtue ethics are already covered because certain virtues are mentioned in code of ethics. That wouldn't take seriously enough the idea of what a virtue is, and therefore in the introduction I really defined virtue. I showed the definition that it's all the way down. It's the way one perceives a particular situation, the way whether one notices certain details. So for instance, a pregnancy, is that relevant or not in how one deals with, so all these sort of knowledge, embedded knowledge, is relevant and should be developed in a piecemeal basis. So that's not enough to just mention these values or virtues in a code.
Yeah, so I suppose I wonder whether that might point us to a more reflexive relationship between outside in and inside out that could be explored. And I'm not sure the idea of friendship towards one opponent is going to go down terribly well with a lot of lawyers. But there is, for instance, the Americans are quite hot on the idea of civility, which might be a better way of expressing what you're driving towards rather than civic
the lawyer
friendship.
as a friend, but and then the limit. Yeah, so interesting. But there's a principal difference between. So a virtue ethical approach does assign really an important role to rules, but it doesn't give priority, normative priority to rules or principles in accounting for what moral quality is. And that's sort of really, therefore they cannot be combined, but rules do have an important role to play in virtue ethics.
I think that's an important point in the context of the scandals that you've identified, because too often the rule has been taken literally, and that's where the miscarriage has been driven from.
And there's a huge gap between the rules also and what is happening in practice, and virtue ethics can account for that.
Thank you. And I can see we've got other questions, so I'll be quiet for now.
Well, thank you. And sorry to cut such an interesting conversation short, but yes, as you say, Stephen, unsurprisingly, given how interesting the discussion between you all has been, we have a number of questions. I suspect we're not going to get through them all, and I'll try and get through as many as we can. So for those of you who have asked a couple of questions, my apologies, I'll just pick one so that we can get through as many people's input as possible. Question linked to some of the conversations we've been having. Are there things a regulator can or should do to strengthen a virtue ethics approach?
Is that the question for me, or?
Iris, I think this is probably.
So if I claim to be, if I want virtue ethical approach to legal professionals to be pragmatic, of course, I also have to come up with something more concrete, I think. So there it comes. I think this proactive management-based regulatory approach to the legal profession would help. So I find it really, really, really striking that, for instance, in the Netherlands, but also in other jurisdictions, and I think the SRA is an exception because they do have a code for law firms, is that we simply ignore the fact that lawyers work in the context of law firms and thus have also limited agency in what they do. And we just have codes that just isolate legal professionals completely and say, this you should do, this you should. And it doesn't make sense if you work in a team, for instance. So I think in that regard, we should regulators could pay more attention also to this ethical infrastructure within law firms, ethical culture, all these difficult concepts, I know, but and also try to think more about sort of the preventive measures that might help for legal professionals, for instance, to be able to advise independently.
I would also echo that. And I just wanted to say just 2 points. One, I think that the SRA has been doing some work on culture in the workplace. So I think that cultural piece is really, really important. But I also think there's a place, picking up on something that's also in Iris's paper about role models, ethical leadership. I think we need to look at ethical leadership within law firms too.
Thank you. And that dovetails a little bit and answers quite nicely another question we had about this relationship between organizational culture and individual responsibility, and how the virtue ethics approach can assist with the challenge and impact of organizational culture. Given we've touched on that, perhaps we'll go straight to the second question that this person's asked, saying, well, how might race and class affect which injustices legal professionals are attuned to or able to engage with? Does virtue ethics have the tools to account for the structural and social blind spots that lawyers may carry into their work?
Yes, thank you. That's also a spot-on question. Another Achilles heel of virtue ethics, which I aim to address in the part of the relational dimension, because I do think that if there's so these scandals have shown a very dismissive attitude on the part of legal professionals towards the citizens that were affected by their handling, and sometimes also discriminatory attitude. And I think for the post office scandal, I'm not sure whether that has also been established, but there's in any case anecdotal proof. But for the childcare benefit scandal, this has been really the case. And I think at this stage, virtue ethics is not yet in a position to, so should do a lot of work. And so that I refer to the importance of diversity.
Moving to a slightly different direction now, might we see a possibility that certain virtues may be understood or valued differently across generations, for example, between baby boomers and Gen Z? Any thoughts on how generational perspectives might shape the construction or expression of particular virtues in professional life?
Yeah, perhaps Karen or Stephen, you want to address this? Or if you have, so on Gen Z, we have perhaps, yeah.
No, I think this is a really interesting question. And I think we need some research on it if someone's not doing it already. Because it's about a range, isn't it, of different life values, right? In fact, I was talking to someone the other day about, how when I started out in the profession, people generally in occupations kind of stayed in an occupation and work your way up, and now there's much more movement, much more lateral movement, etc. But I think, yeah, it's really important to see along with virtues, but also just along with how people deal with the pressures of everyday working, their values, their ideology, I hate to use the word resilience, but we know that resilience and agency. So I'm kind of really answering the question with another question and a call to actually, there's some research that needs to be done in this area, because actually I think there is a danger of thinking that actually what we're talking about is all the same lawyers, and we're not, because perspectives will be different. Perspectives of ethics are different, right? Depending upon where you are in the organization and what role you have, is seniority and your work experience and stuff. So yeah, it's something that desperately needs to be looked at.
This is a really difficult question at one level, because although the virtues may not be entirely innate, clearly there are elements or foundations of those virtues that will be innate, and a lot of it won't be expressed. Some of it might not even be recognized. So I do think there's a really profound question in that question, to which we don't have the answers, and maybe we never will. But I'd also like to put against that the development of AI in law and AI ethics in law, because if some elements of how lawyers practice are innate and hidden and possibly biased. We've got all of those factors that then come into play if we take the output of those decision makers and those actors and use them in AI to produce either predictions or indeed even decisions about legal issues. And we're not even at the foothills, I think, of understanding those issues in relation to human beings, let alone AI. So thank you for that question. It is profound.
And as you say, such important consequences given where the practice is going. I am going to ask just one quick fire question to end, because we are at time, but then we've covered most of the participants' input. How can we, small question to end on, protect and prevent these types of scandals, these miscarriages of justice? It's not that broad, don't worry. For example, how can case management systems be introduced? I know many of you have talked about disclosure and those kinds of challenges that have arisen in these cases. Is there something around case management, some type of precautions we can be taking to try and prevent these issues moving forward?
Well, perhaps this is to abuse this opportunity to also mention one or share my cri de coeur about the importance of social aid lawyers. We call it legal aid lawyers, social lawyers. So in all these scandals also, what is striking is that there wasn't so much legal help from legal professionals. And in the Netherlands, for instance, it's now really the case that there are hardly any students who want to work in what we call then social lawyering practice. So I think also for justice to have still teeth, also for middle income, socioeconomically more vulnerable citizens, we should really take care of funded legal aid that stays accessible. Yeah.
Well, I think an important point to end our discussion on there, Iris. All that remains for me to do is to thank Iris for her paper and wonderful presentation, to thank Karen and Stephen for such insightful remarks and comments, and similarly to thank our audience for their very thought-provoking questions, which show that we could have spent a day on this subject, and perhaps we will revisit again soon. But huge thanks to everybody. As I said, this video will be available on our website in the next week, and wishing you all a very good afternoon. Thank you and goodbye.